Hi, welcome to Smarter Campaigns Candidate Training video blog. I'm Ben Eisenberg, president of Smarter Campaigns. Last time we talked about how to get on the ballot. Today we're going to talk about how to actually stay on the ballot. It's standard practice in politics to challenge your opponent's petition signatures in an effort to get them below that minimum threshold and thrown off the ballot. Why face them in an election if you can prevent them from ever appearing on the ballot? Reasons for challenges include signatures that don't match up with the one on file, incomplete addresses, ineligible voters, forms not properly signed or dated by circulators, and more. In 1996, on his first state Senate campaign, Barack Obama challenged the legitimacy of all of his opponents' signatures. All four of his opponents were disqualified from the ballot, and Obama won facing no opposition. As a candidate, you should plan on having money in your budget for an attorney to fight any challenges. Best case scenario, you don't get challenged and you have extra money in your budget, but I've seen too many campaigns have to fold because their ballots get challenged and they can't afford to defend themselves in court. It's really a shame to see. Now, it's also important you make sure you hire a competent election attorney. I had a city council candidate in a three-way race. Everyone challenged everyone else. Each candidate needed 750 valid signatures. The independent candidate only submitted 778 signatures, so he's only 28 above what he needed. Well, everyone challenged everyone, and as we were looking through his petitions, we saw an entire page of 30 signatures that hadn't been signed or dated by the circulators. 30 signatures removed, candidates below 750, he's off the ballot. So then, there are only two candidates left, my candidate and his opponent. My candidate stopped the challenge of his opponent's ballots because we couldn't get her below 1,000 signatures, and it wasn't worth spending the time or money hiring a forensic handwriting expert or graphologist to actually go through all of these signatures one at a time. And yes, campaigns actually do that. The bigger campaigns with more budget are really aggressive with it. They'll look through every single signature and say, oh, that loop is different, so it must be an invalid signature. And a lot of times they'll win. So then the time came to examine my candidate's signatures. He had gotten 1,150 signatures. He only needed 750. But of those 1,150, he had gone through himself and struck about 200 that were invalid. So he claimed that he submitted 950 signatures. If the opposing lawyer successfully removed just 200 names, he'd be off the ballot. The lawyers challenged 215 names, figuring that that would be sufficient. What they didn't realize was from the perspective of the law, my candidate had submitted 1,150 lines of signature. Those 200 some that my candidate had removed himself were free challenges for the opponent, but because they didn't bother to list each line number, they didn't get credit for it. As such, the judge said, well, he submitted 1,150 signatures, and you only challenged 215, so you can't get him below 750. Case dismissed. Now that, right there, that's legal malpractice. For the opposing lawyer to be unaware of the laws, he really did his client a disservice. That's why it's so important to make sure that you have a competent election lawyer. So, as a general rule, you should really see double the signatures actually needed to ensure that you have enough valid ones, since many people will want to sign your petitions who aren't technically eligible to do so. Either they don't live in the district, they're not registered to vote, but the numbers alone are not sufficient to guarantee you make it. In 2012, a state representative from a major city submitted over 1,600 signatures to the election board. He only needed 300 to get on the ballot, 300 valid signatures, and he submitted 1,600. But instead of legitimately circulating petitions and checking whether they were registered voters, he took his petitions and circulated them around a couple major churches, which weren't even in the district. As such, more than 1,300 of them were not eligible to sign his petitions. And when it actually came time to challenge his ballots, he was below that 300 he needed. And he was shell-shocked. He submitted 1,600, figured he had to get 300 good ones, No. So make sure you're very careful with this. Even in spite of being the incumbent, he couldn't appear on the ballot because he couldn't get enough valid signatures. So to summarize, know the rules. Get more signatures than you think you need, and have good lawyers. Have a great day. Thank you for watching Smarter Campaigns Candidate Training video blog. Please subscribe to us on YouTube, like us on Facebook, and follow us on Twitter.